and indicated we have heard the plaintiff's initial argument and summation. We'll now hear from Mr. LiMandri. Mr. LiMandri, you have the floor.
Thank you, Your Honor. Your Honor, in during opening statement, I pointed out that this, of course, was a very fact-intensive case and that the facts and the context matter. I think we've now seen that the material issues of fact really are not in dispute, but I do want to go over some of them that I mentioned in opening statement that we would be proving and pointed out that they have been indisputably proved. And I also want to point out, as I did in opening statement, as Your Honor indicated and Mr. Mann acknowledges, this case is about a wedding cake and a same-sex couple that wanted to buy specifically a wedding cake for a same-sex wedding. It's not about other pre-ordered baked goods, but the record will reflect undisputably that that issue has never arisen where a same-sex couple wanted to buy any pre-ordered baked goods other than a wedding cake. And also the record will reflect, and it's undisputed, that at no time has a same-sex couple come in and wanted to buy pre-ordered baked products for any type of event other than a wedding. Not an engagement party, not an anniversary party, not a bridal shower of anything of that nature. So not only are they not relevant, but it's completely speculative regarding those situations, and that's not the situation before the court. Now, we know that Kathy Miller opened Tastries in 2013, and despite Mr. Mann's best efforts to make it sound like it's a major corporation who running a factory like General Motors, it really is a small business with some 18 employees. And as Mr. Mann pointed out in his closing argument, that Mrs. Miller is very much involved in all aspects of the business. This business has been very much impacted, as the court has heard, by what's happened over the last 5 years. In fact, half of its existence since late 2012, early 2013, and of course it's impacted all the parties, particularly hard with Kathy Miller, given the avalanche of hateful social media posts and harassment and vulgar type of images and such pornographic images that have been sent to her. So the fact that this trial hasn't indeed been somewhat emotional and cathartic, and we're all happy to see you at this point. There's no question, again, that this is very much an operation that focuses on Kathy Miller's faith. She says it's God's business. She's a steward. It's also a Christian boutique. No one who visits it can think otherwise. And there's no dispute that if someone wants a wedding cake, there's multiple people involved from the front end and the ordering and the back end of the store with all of the designing and baking, and that Kathy Miller wants to be involved and has to approve the final product. So we didn't hear Mr. Mann talk much about this issue of the alternative that Kathy Miller has to have one of her employees make the cake, because it's clear that would involve, about 1/4 to 1/3 of her workforce and her involvement as well, which is simply not a workable solution for her, given her undisputed, sincerely held religious beliefs, and the fact that this is a close-knit, family-like operated business, and that it would be very disruptive to the business if people were at cross purposes in terms of what the mission and purpose is of the organization. And as Kathy Miller has said, in how her testimony reflects and that of the other witnesses with no dispute, she seeks to serve God in all things in her work. And that includes being true to her biblical principles that she's learned and seeks to follow, which is why the design standards in the last number 6 say that she's going to seek to follow Christian principles. Now, Mr. Mann points out, yes, but supposedly she made a wedding cake for a heterosexual couple that had been living together. But they went to get married. So they made a wedding cake to celebrate the fact that they were doing the right thing. So I certainly see no inconsistency there. And kind of surprised he brought up the atheist issues, and she explained how she basically seeks to evangelize, right? The Christians have the Great Commission from our Lord that we're going to evangelize, and she does it openly and freely, and apparently not to the chagrin of anybody who's ever bought a wedding cake at Tastries among the thousands of customers that have come in. She shares the wedding packet, Exhibit 5, and quite freely and openly talks about the many biblical references regarding marriage and how it's a sacred institution ordained by God in Genesis. So I have to correct one factual error in my opening statement, which unfortunately my wife was quick to point out when she was here, that I said that Abraham wrote Genesis. It's Moses, so that was apparently an unforgivable theological faux pas on my part, which I shall not repeat. Other than that, I believe I've been factually accurate with the court, and as I'll proceed through my closing argument, I hope the court will agree. We know how the wedding policy came about. I'm not going to recount in painful detail all of the issues that really are not in dispute in that regard. Clearly, the design standard as it involves marriage is between one man and one woman, irrefutably biblically based, as I indicated, both testaments of the Bible, multiple books with no room for interpretation anywhere, nor do I know anyone who seriously suggested otherwise. So Kathy Miller, if she's a devout Christian, she's really put in a situation where she has to either lose her faith or lose her business based upon the interpretation of the DFEH of the UNRUAC here. And she even consulted her pastor, she said, Roger Spradlin. She wanted to make sure she's doing the right thing and has remained basically convicted in her heart. She has no choice on this issue. And, let's be clear, when we talk about the Christian principles, I mean, we're not talking about small things, basically life and marriage. We all know in our culture today, those are the hot button issues. And in the case of Baker, it's going to show up with regard to the marriage issue, not any potential myriad of unrealistic hypotheticals, which fortunately we did not have to address. And with regard to the making of a wedding cake, there's no dispute. It's right in the plaintiff's trial brief on page 10. The customer has to work with the baker, the representative of Tastries Bakery, to select the size, the shape, the flavors, the fillings, the design work, the color, the texture, and, professionally, it was a bit insulting to our client, given her lifetime commitment to her vocation, to suggest that she basically only uses cake mixes, which is absolutely flat false. As other bakers, particularly in the climate, sometimes they have to use either cake mixes or frostings, but they oftentimes will bake their cakes completely from scratch, and when they use the mixes, it's only for the foundation with recipes of long-standing and creative design that are used with them. And I only say that because for someone who's a professional baker, suggesting that they do all their baking with cake mixes is like telling an artist who sees themselves as a great artist as basically painting by numbers. And so that's why that issue probably looms a little more important than it otherwise should, given the weighty constitutional issues in this case. But one thing is for sure, Kathy Miller cannot operate Tastries Bakery in such a manner they can continue to keep their doors open without wedding cakes being 25 to 30% of their business. And although Mr. Mann points out the UNRUAC's been around since 1959, with a few major categories that have always been recognized, or at least long recognized in the history of our nation. Certainly religion being a protected category since the nation's founding, and in fact was the inspiration for the nation's founding, with the Pilgrims being religious refugees and our founding fathers putting free exercise of religion in the First Amendment of the U.S. Constitution, not just freedom to believe what you want, but freedom to put it into practice, not just in church on Sundays, but in all aspects of your lives, including in the marketplace. So freedom of religion has always been in the Annual Act. This issue of same-sex marriage has really only appeared to be addressed by business owners since around about 2015, and shortly thereafter, as was exactly the case with Kathy Miller. And the fact that it's caused confusion, not just for her, but for many, is just an unfortunate and inevitable reflection of the fact that when you take an institution that predates recorded history and basically found itself forming in every society that's ever existed in the history of the world, from small, tribal villages and tops of mountains or in deserts or in jungles, human beings always matched up in a marriage of one man and one woman. Obviously, is a need to perpetuate the species, but because also apparently they just thought it was the right thing to do without anyone telling them they had to be done, including ancient pagan cultures in Greece and Rome, which never would have imagined marriage would be a state institution, even though they were quite tolerant of homosexuality. So the fact that there's some confusion, which was reflected in the testimony as Kathy Miller, a devout Christian, struggled to try to harmonize the questions of the state of California's representative in what the new definition of marriage means in terms of sexual orientation, should not be a surprise to anyone under this new secularist regime. Now, as to the claim of discrimination, obviously that has no real teeth. No one here has come into court with any experience with Kathy Miller of any kind of duration with her interaction with her gay customers who she's hired and rehired, not gay employees she's hired and rehired, and gay customers who she has served with as much faithfulness and devotion as any customers. No one has suggested she does so in any type of discriminatory fashion. In fact, all the evidence is to the contrary. And what makes this case distinct from other cases that DFEH wants to cite, Your Honor, is where they found violations, it was almost always where there was a complete denial of services. They cite one race case where supposedly a restaurant owner would not serve black people in all sections of the restaurant. No one's going to argue with that. And the cases have pointed out, and that's why we've taken umbrage, it's highly offensive to equate the race court cases to people's sincerely held religious beliefs about marriage, because any rational person realizes any discrimination based upon race was always arbitrary and always invidious and always ugly. We fought a civil war where 600,000 people died to make sure that never happens again. And it does not in any way equate to people's sincerely held religious beliefs about marriage, even in the sterile legal environment of a courtroom where you're talking about it as some type of legal precedent. And certainly not in the confines of a law office conference room where someone is being deposed and interrogated on the sincerity of their religious beliefs in a somewhat mocking fashion, which should never happen in the United States, which was, again, founded first and foremost by people seeking to escape religious persecution. Now, as to this allegation of discrimination and hostility or animus, which obviously does not exist on the part of Kathy Miller, it is clear that she does not just refuse to make wedding cakes for same-sex couples. And it doesn't matter who comes in to order the cake, whether they're heterosexual or homosexual, she's not going to make that cake. And we see that distinction made in cases like, all cited in our brief, like the Lexington case and even the UK Supreme Court. They tend to be more liberal than even us these days, but they said, making this cake was ordered by a corporation to celebrate gay marriage, and they said, it's not a gay person ordering the cake. It's about the message. So this is a universally held idea that making a cake, particularly a wedding cake, is in fact to endorse what's occurring in that marriage. It is in fact about speech. It's not about the persons individually. However hard the DFEH wants to shoehorn the concept of marriage into the idea that it is synonymous with sexual orientation. The fact is, as we all know, not all heterosexuals marry. It's not an immutable characteristic of heterosexuality to be married, and it certainly isn't of homosexuality either, since the incidence of marriage is even much lower. So there's something that's unique and different about marriage, regardless of one's sexual orientation, as to whether people find it as right for them. But as far as sending a message, Mr. Mann, I think, stated it quite eloquently just minutes ago when he said, a passerby, when Mike Miller was passing by with a wedding cake, said, oh, it's a wedding. That is a message. And when the DFEH sees on that point 6 of the divine standards that only a wedding cake for a male and female will be made, the distinguishing factor is it is a wedding cake. And that connotes in people's minds, almost universally, a 3-tier or more white wedding cake. There could be exceptions, but again, exceptions never define the rule. And as I hope to be able to show some slides when I get to them of what Supreme Court justices have said on this issue, it basically is what people universally would think, what Kathy and Mike Miller both testified to yesterday, people have indicated they think when they see a wedding cake and they see the pastries people bring it in with the logos on their shirts and the business cards and such, that pastries is supporting it. And the interesting thing, Your Honor, if they were to convince any judge that making a wedding cake, a simple cake, is in fact not speech because it's not particularly elegant or complex in its design, then where does it stop? Then does it mean a more elegant cake? And how much more elegant would be speech? And you'll see, if I hope I get to these slides, one of the justices said, what about writing? Do you need writing to make a speech? I said, no. Again, people know what a wedding cake is. But if you do need writing, does that mean Kathy Miller can make wedding cakes but not put writing? And remember the question of Justice Ginsburg at the Supreme Court masterpiece to the ACLU lawyer, would the baker have to write, God bless this union, on a wedding cake for a same-sex couple? They said, yes. Or, I guess, no writing. But I don't think you make wedding cakes and say, no writing. And then you start getting into, well, if there's writing, where does the writing stop? You have Mary Johnson, who came in here looking somewhat different than she did in her video depo, both in appearance and demeanor, who would say you have to put Hail Satan on the cake. Your religious beliefs have nothing to do with what the customer wants. I believe Eileen said the same thing. You have to make a pornographic cake if that's what the customer wants. So where does the speech stop once they get what they want on a simple wedding cake? Basically, we know it doesn't stop at all. It never does. It's maybe incremental at first, and then it's a very quick, slippery slope into you have to give up all of your religious beliefs when it comes to these issues, and all of your rights to free speech and free exercise of religion. And that's how tyranny works. And that's completely against everything the founders intended when they wrote our Constitution. We know that even Patrick Salazar, who had some very strong views on people who would dare to hold biblical beliefs against gay marriage, that they're all hateful bigots. Anybody who believes what the Bible says is a hateful bigot. Anyone who voted for Proposition 8 is a hateful bigot, which means the majority of Californians who voted and 2/3 of the people in the United States who voted, who passed constitutional amendments in 31 states, were all bigots. But separate and apart from that, he did say Kathy Miller was very compassionate and nice. She wasn't rude. She tried to express herself in a way that would be as inoffensive as possible. It's very unfortunate the situation arose because of the recognized, and I appreciate the acknowledgement of the state of the deception on the part of employees who are working at cross purposes. If they had not done what they did, this would not have happened and none of us would be here. Because the accommodation that Kathy Miller had put in place had been working and had been successful, and undoubtedly would have continued to be because of the sensitive and compassionate way she tried to go about dealing with this situation so that she could not only preserve her sincerely held religious beliefs, but also see that a same-sex couple got the cake that they wanted, which is why she put that arrangement in place with a very talented baker who uses comparable recipes and is a member of the LGBT community to be able to provide that service and never received any complaints from anyone about that accommodation. I'm not going to go into the details of the subject incident. The court is all too familiar with them at this point, but I do want to point out we still find it anomalous that the real parties came into Tastries and made up their mind, they said, on the first visit before they tasted any of the products, that they were going to get their wedding cake from Tastries. At least one of them recognized all of the religious symbols, playing Christian music. Why did they have to have Kathy Miller make that cake without even tasting the product, which was freely available for them to do when they came back the second time? We're standing there in the design center for wedding cakes with all of the cupcakes laid out, and were invited to taste the cupcakes before Kathy Miller came and before she realized it was the same-sex couple. So we do find that anomalous, and although I do believe, Your Honor, they were shopping for a wedding cake because they got a wedding cake and they had a ceremony, I do also believe that, well, I should say, the evidence has shown that there was more at play, in as much as they were insisting Kathy Miller make the cake when there were many other bakeries willing to do it. And it also seems highly coincidental that they were able to bring to bear in such a relatively short period of time a complete firestorm. And although they tried to deny they ignited the flame, even though in their small group they got involved notorious militant gay activists who said they were going to take this to the whole world, and did, and rained down again this firestorm where they had to lock the doors. The real parties continued to fan those flames, using social media to their maximum advantage, and never, even after they learned what was happening, sought to in any way cause the uproar to die down. Again, they fanned the flames by writing hateful things about Kathy Miller themselves and telling lies about her being a bigot who would not serve gays and lesbians. And even knowing what happened, 6 employees feeling threatened, some of them leaving for that reason, and all the other things where they had to lock their doors when the media were kind of trying to get in the shop. It's their view, even still, they want her doors locked permanently. They want her out of business. They want her punished. They want to send an example to anybody, I think, who dares to have her views. And what is the harm they're claiming? That one of the real parties apparently cried and had a headache and had a nosebleed. Hardly stands in comparison to the harm Kathy Miller has suffered, and it is relevant for strict scrutiny on the balance of harms issues. And although I don't want to press this issue too hard, I think it's incumbent on me to point out, I don't think it was a lack of service or a refusal or denial of service. It was, as I believe Morena Rodriguez Del Rio said, no one had ever confronted her. And Kathy Miller did not want to do that. Eileen pushed her 3 times. Why are you trying to refer it? Why wouldn't you make the case? And only after the 3rd time did Kathy Miller, she didn't say, I don't condone same-sex marriage. She said, I can't do it. I can't hurt my Lord and Savior. And I think that was the message that caused that small group to go out and have her savagely attacked. And is it a hurtful message to them? Perhaps it would have been, but it was Kathy Miller's right, and indeed, as a Christian, her obligation to speak the truth in that situation. And in as much as they're trying to punish her for that truth, that is viewpoint discrimination. That is unconstitutional, and that must not be allowed. And I will point out, I mean, who was the victim there? One of the men put his hand on her back, reached around and grabbed a clipboard out of her hands. They said they didn't touch her. I learned in law school, you even kick some guy's cane, it's an assault and battery. You know, grabbing that clipboard and putting her in apprehension of imminent danger, which she said she was scared. I am not saying, obviously she's not filing charges for battery, but I'm saying look at what happened. What they did to her under the law is worse than what they accuse her of, even if they just grabbed the clipboard out of her hand and said, we'll take care of this, and stormed out with her proprietary custom order form that is not to be released to the public, which they took and left her there basically in shock. Now, this situation we know will never happen again because procedures that Kathy Miller put in place to avoid it, which now, of course, they're holding against her, making it sound like that in and of itself is some type of insidious discrimination. But there's no question there was coordinated attacks involving the media and no attempt to rein them in. And you know, I'm not blaming the DFAH for what their clients did initially, but they could have said, please post on your Facebook or whatever to stop the harassment. This is not what we intended. Our lawyers say this is a legal issue, will be appropriately addressed by the courts at the appropriate time. Please don't do this anymore. I'm sure Kathy Miller would have been happy to do the same if there had been a need for it. That was not ever offered. In terms of the balancing of interest and the harms, we know that the real parties did get their wedding cake, 3-tiered cake. I've got some slides, I hope I get to them, where they both testified. They thought the wedding cake they got was beautiful. They thought the cake was delicious, and it was just like the cake they would have liked to have got from Tastries. So there is no question there. Then we have legal authority, Justice Baxter, in the North Coast case that Mr. Mann cited multiple times, said that the situation with this medical clinic would be different if, in fact, there was a sole proprietorship, which is basically what we have here. And I do have a slide on that, so I want to come back to that. But the bottom line is the real parties wanted a traditional wedding. They got a traditional wedding. They even had a topper they could have put on the cake, decided not to, but again, would our client have been required to put a topper with 2 men or 2 women on it if that's what a gay couple wants? And beyond that, real parties received offers of free photography, and makeup, and hair. No economic loss, and I already talked about the emotional loss. In fact, there are many celebrities in the LGBT community who went to PFLAG, made an appearance. But the message here, and that's the most important point, was not one of discrimination. The message was one that they would not be able to support a marriage that was not one man and one woman. And since Kathy Miller's religious beliefs are not in dispute, you'll see in the UNUAC cases, and I see I was given a note by my colleagues, there's one more point with regard to this issue of balance of harms, that Jessica did show up to cut the cake. It's a service that Kathy Miller offers through Tastries. Is that something they would have to do? Have an employee go to a same-sex wedding? I'm sure they'll say, no, you just stop offering that service. But by the time the DFEH will be done, they can't offer any services without violating the conscience of the person who owns it, whose reputation and brand is reflected in everything that Tastries does. As to the UNUAC, we have a slide I keep talking about them that I want to show you with the Sargoy case. All these cases are cited in our trial brief, Your Honor. It states that the intent to discriminate has to be arbitrary. That's what it says in Badgie. We cited Badgie because it has the affirmative defenses Cassie does not have. But arbitrary means that it's invidious, like race-based discrimination, and that there's no legitimate business interest or public policy interest. Well, here the legitimate business interest is, this is Kathy's brand. Everybody knows who she is and what she stands for that does business with her. And also, she's got a constitutional right. So clearly, there's a public policy interest in the state not forcing her to send this message. Mr. Mann says they can't disentangle same-sex marriage from sexual orientation. And I say, why? You can only disentangle it because of co-opting the language regarding the label of marriage and then grafting it onto sexual orientation. Like I said, they're two distinct concepts, and no court has said that sexual orientation and marriage necessarily go together. They cited the Christian Legal Society case, but there, homosexual was prohibited from membership at all in the organization, and there was no expressive speech. No one was being asked to create something from scratch. And remember, we're not talking about selling a pre-made product. We're talking about having them create a work of art, which all of their witnesses, I think with the exception of Eileen Rodriguez Del Rio, acknowledged, it was art. I think even Patrick Salazar did that. Certainly Mary Johnson did that. Certainly everyone who was in the baking side of the case did that, including Melinda Massey and, of course, Rosemary Perez, of course, Kathy Miller. And you can see it. You saw it for yourself. That's why we put those exhibits in. And I noted the court studiously observed those. So it's clear that this cake making at this level is artistic. And in any event, who gets to decide? Again, all speech is protected. It's not always eloquent. It's not always a great speech maker. It could be banal. It could be boring. Could be like my closing argument. But it's still protected because it's speech. And same thing with expressive speech. Now, a wedding cake is unique. It does send a message regardless of the degree of detail. But on this UNUAC point, there's certainly no arbitrary or invidious discrimination when people are asserting their constitutional rights, and particularly when there was an effort to provide an accommodation, which someone doesn't do if there's invidious discrimination. Again, I'm going to quickly talk about some of these key cases, and then we're going to look at some slides. North Coast, though, is certainly distinct because it involved professional physicians with a fiduciary duty providing an essential service. And the same is true of Minton. And in Minton, they said if they had set up the accommodation in advance of the person coming in selecting the service, that would have been different. And that's exactly what Kathy Miller did. We also cite I didn't cite the Harris case because I didn't think there would be an issue, but Mr. Mann pointed out they're relying on CASI 360. Then if I heard him properly or correctly, he said that there is no case law to use substantial for the motivating reason element, but in fact, right in the use note for CASI 360 at the bottom, it cites the Harris case saying you need to have a substantial motivating reason. And that's also in Badgie 7.92 we used because it also included the affirmative defenses. By the way, they're both written by the Judicial Council. It's my understanding basically Cassie modernized the language, made it more reasonable, didn't change the law. They're both highly respected and they both have substantial in the jury instruction. So I don't think the state should be trying to convince the court that's not a proper element under these circumstances. We cited the Hobby Lobby case because there are two defendants, and Tastries, although it's a corporation, is a closed corporation, family-owned, and therefore it enjoys both free exercise and free speech protection as the large Hobby Lobby corporation, which many different outlets, but nonetheless a closed corporation and family-owned. We cited the in-ray marriage cases from the California Supreme Court. It said religious beliefs regarding marriage are protected for persons in California, as did the U.S. Supreme Court in both Obergefell and Masterpiece, said religious beliefs are protected. I got those slides, hope to show them to you. In Fulton, more recently, the U.S. Supreme Court said that religious liberty won out over clash with sexual orientation rights because the gay couple who wanted to adopt a child had other options to do it. And even though it wasn't a statutory accommodation case, it was an accommodation case, contractually, and the same principles applied, and strict scrutiny was applied, and the religious organization Catholic Charities won. Even though in Minton, the religious organization Catholic Hospital lost because they did not have accommodation set up in advance like Kathy Miller did. And we also see strict scrutiny being applied by the U.S. Supreme Court in more recent cases that were cited issued by the Supreme Court just last year on religious liberty and the opening the churches back up. Camden and South Bay, I indicated South Bay was our case. The Supreme Court applied strict scrutiny to those cases because the state of California was not acting within the rights of religious adherents. And they're kind of harsh on the Ninth Circuit. So look, we told you now 3 times, don't keep the churches closed. And based on our case, they vacated Ninth Circuit contrary authority that did not apply strict scrutiny. In the Hurley case, the United States Supreme Court held that you can't force people to adopt a marriage of promoting LGBT rights. You couldn't, although gay people could march in the St. Patrick's Day parade. Was that St. Patrick's Day? It was St. Patrick's Day. They couldn't hold up their own banners. They couldn't co-opt the message of the St. Patrick's Day parade by using it for their message. And even though the Kennedy case was a free speech case issued just last month, the court had very strong statements about the importance of free exercise of religion and speech, saying that religion is doubly protected because the founders wanted it that way. Much of the speech that was controversial was religious. So they wanted both the free exercise protection and the free speech protection. And that's how the Supreme Court has been trending, with a more originalist view of what did the founders really intend, looking at our tradition and our histories. As to this, and there is one other case pending, 303 Creative, that's been fully briefed, will be argued in the fall at the Supreme Court, probably have a decision certainly by this time next year. And I'm not going to be one to predict what the Supreme Court will say, although, again, they've been trending protective of religious liberty. But I will point out an argument that I think is very appropriate that was in our amicus brief we filed on behalf of African American civil rights leaders and pastors, who said it's wrong to compare conservative Christian views on marriage with racism, because the more apt comparison are pro-life views. I said, you can't say if someone is pro-life that they're bigoted against women. You know, that is one issue that involves women, because historically only women could have abortions, okay? But you can be pro-life and still be for women's rights. And in this case, you can be pro-marriage and not be against gay people, as is the case with Kathy Miller, who's happy to serve gay people in all aspects of her business and all aspects of her life, other than this one issue carved out for marriage, which is, again, necessarily, in this case, separate from sexual orientation to apply the constitutional issues appropriately. I'm just gonna kind of more quickly, but court reporter is looking at me funny, so I guess we're not.
It's not gonna let you do anything more quickly.
I know, and rightly so. But as to the hostility of DFEH, I feel it's necessary for me to mention again, saying that they did a full and fair investigation in the investigatory phase without ever talking to my client and they relied on some media snippets, is simply laughable. That's not a full and fair investigation, not to get her view, but just to rush into court less than 2 weeks before Christmas and try to shut her down and send me voluminous interrogatories, which I stayed up 3 nights in a row to answer, and then not waiting for the answers before they did that. And then getting, I guess, the unnamed judge who wrote a scholarly denial of the TRO, basically on these facts which have not materially changed, and still rushing back into court, which in Masterpiece was looked at when the Colorado Civil Rights Commission lost on the marriage issue, went after the same man on a transgender case, that was retaliatory. And I believe this is also retaliatory. The state lost, but yet without a change in the facts, they're coming in still making these same non-meritorious arguments. The DFEH, besides certain we consider burdensome and duplicative discovery, and taking duplicative depositions of Kathy Miller, Mike Miller, Rosemary Perez, and asking very unfair hypotheticals about unrealistic situations which have never arisen before and are likely to never arise. Also, making offensive comparisons to racism at the deposition. I've got some slides on that. And also the disparaging questions about biblical prescriptions against eating shellfish and pork and such is, in fact, tantamount to mocking one's faith, or at least the sincerely held beliefs they have in that faith. And the DFAH, we feel, ratified the hostility of their clients by taking no steps to repudiate them and have them mitigate the harm, the horrible harm that they were causing my client to her business, and the effect on her as they would on any person receiving that type of vitriol in an unrelenting way. And then there was that text about the blue wave, if the real parties were quoting the DFEH correctly and fully. I think that also goes to that point. So, final points before I look at the slides that track the badging instruction that we provided to the court is that the wedding cake itself embodies the message. The message is one of celebration of the marriage, and the message is the marriage is acceptable to the people who are making and providing the cake. The wedding cake is clearly artistry, is expressive speech. Therefore, free speech protection applies to it as expressive speech. The fact that someone is offended, again, does not overcome the free speech rights. We have free speech protection for the exact reason that some people are offended by the speech, or we wouldn't need those protections. Again, the most recent cases from the United States Supreme Court are increasingly protective of religious liberty rights, including Fulton, including Kennedy. And I did want to mention, because I think it's appropriate since we are doing this work and handling this case under the auspices of the Thomas More Society, I think it's particularly appropriate that he was a great hero of conscience. He was a patron saint of both lawyers and judges, Lord Chancellor of England, second power and prestige only to the King Henry VIII, but he would not attend the king's marriage when the king wanted to divorce his wife and marry his mistress without the church permission, and the king made himself head of the church so he can grant his own divorce. Thomas More represented himself at the trial after 15 months. It was a show trial because Henry VIII's mistress, Anne Boleyn's father, brother, and uncle were on the jury. Not like our trials today. But Thomas More made similar arguments that the king had recently passed a law making him head of the church. But More said, we got a higher law tantamount to our Constitution, which was their Magna Carta, that promised the independence of the church, and prosecutor didn't like that. He said, that just shows they're malicious, and malice is what they needed to accuse him of treason. And then More also invoked the fact that the law was insufficient in law to charge any Christian person because it went against the law of God and what Christ himself established when he was on earth in human form with regard to the issue of marriage and the independence of the church. Those arguments were unavailing there, but the state was a little more merciful in that case. They did not, while Thomas More was in the Tower 15 months before they cut off his head, force him to go through the indoctrination that the state of California is asking this court to impose. If we look at the first slide, 32, taken from page 29 of the plaintiff's trial brief, they're asking this court to issue injunctive relief that's going to require our client to have a written policy regarding the eradication and prevention of discrimination on the basis of sexual orientation. I see eradication as something like you would do with some type of insect infestation or disease. They're going to have to eradicate these pernicious religious beliefs that the state now finds objectionable. And they're going to make sure that my client would conduct or obtain a minimum of 2 hours of in-person training annually for a period of 5 years on complying with the UNU Act, including training on the policies and procedures described above. It sounds to me like something out of the Soviet Gulag or communist China on a re-education camp, where our client will have to, like Thomas More, be forced to basically renounce her faith and adhere to the new secular orthodoxy. And that's what they're asking this court to do with this type of injunction on these type of issues. And make no mistake about it. Let's look, though, at what the state should be doing. And I'm going to take this slide right out of their trial brief, this slide 31, and it's page 1, lines 24-27 of the state's trial brief. Miller holds a sincerely held religious belief that marriage is between a man and a woman. DFEH does not dispute or question her sincerely held religious belief. Freedom of religion is one of our nation's fundamental values and is protected by the First Amendment, the California Constitution, and the UNU Act, which we're here talking about, that the state should be seeking to protect that long-standing right. But we're not hearing much about them with regard to the UNU Act. Now, I skipped over a couple of slides. One of them was North Coast. Let's look at it now. Slide 28. I had 6 points that I think make it distinguishable. Again, medical care is an essential service, and that was an issue in both the North Coast case and in the Minty case. 2, the doctors are licensed professionals who have a fiduciary duty with their patients concerning private health matters. And that case was involving artificial insemination. We're not talking about buying a wedding cake. We're talking about a professional service involving the most intimate private and confidential matters in a fiduciary relationship setting. Also, the doctors are working independently of each other in a business relation, not operating under a sole proprietorship like Kathy Miller, who has to supervise her own staff. So you don't have a situation where Kathy Miller can just refer it to someone on an equal level at K Street. She has the final approval over all the wedding cake designs, unlike these doctors who are working independently. Number 4, Kathy could not be certain of being able to provide full and equal service if she was not involved in supervising the creation of custom wedding cakes by her own employees, because she's the quality control person. 5, the doctors did not have free speech claims because their medical services are not a form of expressive speech like Kathy in making a wedding cake. That's the key distinguishing factor with regard to free speech, and that's not showing up in any of the cases that the defendants are citing to the court with regard to expressive speech, where you're forcing someone to create a work of art that takes hours and much skill developed over many years. And finally, we believe the Fulton case from the Supreme Court of the United States is the higher and more recent authority than North Coast, and Fulton only required other comparable service to be available, not even on a referral basis. They simply said gay people can adopt kids from any number of adoption services. They don't have to shut down that particular Catholic adoption service, but they did mention one of the problems was there was exemptions available under the arrangement that the hospital had with the government authority, but also under the Annual Act there are exemptions. There's exemptions for age, disability, regard to driving and such, but also there's a catch-all exemption that if there's any other law contradicts it, UNRU is not going to countermand that law. Well, gee, we have a couple of important laws, the federal and state constitutions with the rights that apply to them, which we'll talk about. There's also a concurrence in North Coast, slide 29, from Justice Baxter, which is right on point, that I mentioned. I'm not so certain this balance of competing interests would produce the same result in a case of sole proprietor, who arguably is a business establishment for purposes of the Unruh Civil Rights Act, at least where a patient could be referred with relative ease and convenience to another practice. I question whether the state's interest in full and equal medical treatment will compel a physician in solo practice to provide a treatment to which he or she has sincere religious objections. These issues are not before us here, however, and the majority does not express any contrary views on them. They are an issue before this court because Kathy Miller is a sole proprietor in that sense. There's also the case site I love from the defendant's opposition to the plaintiff's opposition to the defendant's motion limiting number 9, but it's also on page 25 of the trial brief, the Spence case, which I did cite, slide 30. It said that DFEH said, in the context of a bakery, conduct such as baking and selling baked goods may become sufficiently imbued with elements of communication to receive free speech protections, where an intent to convey a particularized message was present, and in the surrounding circumstances, the likelihood was great that the message would be understood by those who viewed it. That's our case. And there's no testimony to the contrary that our clients did not intend to convey a message, and there's no evidence to the contrary that the people who go to weddings would not understand what that message would be. The next slide is 31, we already showed that, okay. And then 32, I'm trying to probably show that. Okay, so let's move on to our burden of proof slides. How much time do I have? 53 minutes?
No.
I have one? Just, okay. I think I have 20 minutes? All right, that's not enough time. Okay, looking at slide 16, dealing with the Unruh Act, we took from Badgie, Book of Approved Jury Instructions, 7.92. Again, point 2, that the plaintiffs want to ignore. It has to be a substantial motivating factor for for discrimination. Sexual orientation was not a substantial motivating factor under the Unruh Act. it was not wanting to express a message about marriage other than one man and one woman. Let's go to slide 8. I'm going to move through these quickly, but I'll try not to read too quick. Slide 8 is from the Masterpiece Cake Shop case. It says there is some force to the argument that the baker was not unreasonable in deeming it lawful to decline to take an action that he understood to be an expression of support for their validity when that expression was contrary to his sincerely held religious beliefs, at least insofar as his refusal was limited to refusing to create and express a message in support of gay marriage. Let's go to slide 9. This is Asher's case that we talked about from the United Kingdom. We do cite in our case law, as the United States Supreme Court did in the Lawrence case, which made same-sex sexual relations a constitutional right, foreign law. I believe they did in Masterpiece too. But here, again, the UK Supreme Court, looking at Masterpiece, says clear there's a distinction between refusing to produce a cake conveying a particular message for any customer who wants such a cake, and refusing to produce a cake for the particular customer who wants it because of that customer's characteristics. Again, this was a cake for same-sex marriage celebration bought by a corporation, and they said it wasn't based upon the characteristics, it was based upon the message. Exactly our argument. Number 17, with the UNU Act, we have, is that number 7? Okay, number 17, in the instructions on burden of proof, one of the elements was the discrimination arbitrary. So if we go to the Sargoy decision, slide 10 I mentioned, here's what it says. Neither the language of UNRU itself nor the interpretation of the UNRU Civil Rights Act by the California courts have held all distinctions based on age, but that was, one factor here. Other particular protected characteristics would include sexual orientation. Not all distinctions are unlawful. Rather, the California Supreme Court has held that UNRU prohibits only arbitrary, invidious, or unreasonable discrimination. It goes on. California courts have uniformly found discriminatory treatment to be reasonable and non-arbitrary where strong public policy exists in favor of such treatment. Again, it's cited in our trial brief, but that's exactly our situation where you have the United States Supreme Court and the California Supreme Court in slide 12 in the in-ray marriage cases stating, finally, affording same-sex couples the opportunity to obtain the designation of marriage will not impinge upon the religious freedom of religious organization, of any religious organization, official, or any other person. No religion will be required to change its religious policies or practices regarding same-sex couples. So, but they say no, or any other person, official or any other person, will have their religious freedom impinged. That's our California Supreme Court. We saw what the United States Supreme Court said. Where is that promise being lived out in what the state of California's representatives are trying to do to my client in this case? Let's go to slide 18, in terms of the burdens with regard to the California Free Exercise Clause. It specifically states one of the essential elements of the defense. Does Kathy Miller case possess a sincere religious belief that motivated their conduct in this action? Again, that's not in dispute. Go to number 13. Just last month, the United States Supreme Court said in the Kennedy case, the Free Exercise Clause provides that Congress shall make no law prohibiting the free exercise of religion. And it goes, this court has held the clause applicable to the states under the terms of the 14th Amendment. The clause protects not only the right to harbor religious beliefs inward and secretly, it does perhaps its most work by protecting the ability of those who hold religious beliefs of all kinds to live out their faiths in daily life through performance or extension from physical acts. Again, citing the earlier employment department case. Let's go to slide 19. How much time do I have? The strict scrutiny requires the state show on all of these constitutional defenses both a compelling government interest and the least restrictive means. There's no compelling government interest, Your Honor, that Tastries has to make these wedding cakes. Okay, they have provided certainly a less restrictive means of enforcing any type of policy for full and equal services to same-sex couples through their accommodation system, by which the Rodriguez del Rios did in fact receive exactly what they wanted and more for free. So this is the worst case for them, actually, because you got someone with undeniable, sincerely held religious beliefs and a couple that has not been harmed in any material way. So the balance of harms clearly weighs in favor of my client. Let's look at slide 6 from Maria Rodriguez. And what did you think of the cake that you got from Tears of Joy? I think it was delicious and beautiful. I like the way it came out. That's her trial testimony here in court. She also said, this is a wedding cake that Jessica Cariello made for your wedding, right, ma'am? Yes, without the flowers. And this is similar to the cake you wanted from Tastries to make for you. Isn't that true? Yes, close to it. So they got what they wanted from Tastries. In fact, they got it from a former Tastries baker. Jessica Cariello worked for Tastries. I mean, how much closer can you get to getting full and equal service? Let's go to number 7. Likewise, Eileen Rodriguez del Rio stated, and was the cake, I might have asked you this, the cake that you have with Tears of Joy, that's Jessica Cariello's cake, the one similar to the one you wanted over at Tastries? Yes. And then also she was asked, thank you, you guys ended up getting the cake that you wanted ultimately for your wedding, right, ma'am? Yes, sir. Let's go to number 20. With regard to the free exercise clause, again, federal free exercise clause of the U.S. Constitution. Kathy Miller, again, of his sincerely motivated religious belief. And was the DFEH's administrative investigation or prosecution neutral? No, it hasn't been. Let's look at deposition questions, slide 2 through 5. She was asked by the DFAH at her deposition when black people in the South before the civil rights laws in the 60s went to a restaurant, they were denied. There were lots of restaurants they could go to, right? Next. And then also, are you aware that the business owners, certain business owners in the South did say that their beliefs were that God did not want black people and white people associating together? Next. Do you try to follow everything the Bible says? And then Kathy answered, I do my best, but I'm a sinner, but I do my best. Then do you follow some of the eating practices from the Old Testament? Mr. Jonas objecting. And Mr. Mann says in terms of not eating pigs, not eating shellfish, etc. Next. Is that it? The next one is for Mr. Jonas. That's harassing and argumentative. I'm not really sure where you're going with this, Greg. I'm not going to let you cross the line here and start harassing Mrs. Miller. And Mr. Mann says, I don't know how that's harassing. She just says she tries to follow the Bible. I'm getting in one on to another colloquy, but it is harassing and it was not appropriate. Next section, slide 21. Here's the under Civil Rights Act. Is it facially or is applied? Is it not neutral, not generally applicable? Again, I discussed these two factors. Go to slide 34. Here's what Fulton said, United States Supreme Court, fairly recent decision. A law burdening religious exercise must satisfy strict scrutiny if it gives officials discretion to grant individualized exemptions, which the Iowa Act does. It's got in 51C a broad-based exemption. And where such a system of individualized exemptions exists, and it does with regard to, again, some disability cases at least, the government may not refuse to extend that system to cases of religious hardship without a compelling reason. How much time do we have? Okay. In 22, the compelled pure speech cases, again, was what making wedding cakes, is it a form of speech? Let's go to 33. This is from the plaintiff's trial brief, page 27. Not the plaintiff's, the plaintiff's DFE. The compelled speech doctrine, which requires strict scrutiny of review, applies when the government forces an individual to speak a specific message because free speech protections prohibit the government from telling people what to say. That's what the DFEH is trying to do to Kathy Miller. They're trying to tell her what to say, and making a wedding cake in support of same-sex unions, marital unions. Number 14, quote another quote from Kennedy, which is just this year, just last month. The free exercise and free speech clauses work in tandem, where the free exercise clause protects religious exercises, whether communicative or not. Free speech clause provides overlapping protection for expressive religious activities, which is what this cake making is. That the First Amendment doubly protects religious speech is no accident. It is a natural outgrowth of the framers' distrust of government attempts to regulate religion and suppress dissent. Exactly what we're talking about here. In Anglo-American history, the government suppression of speech has so commonly been directed precisely at religious speech that a free speech clause without religion would be hamlet without the prince. The other nice comparison with St. Thomas More, he was the first person as Speaker of the House of Commons before he became Lord Chancellor to argue for free speech, which Parliament did get. So he's again another fitting example. Slide 23. Won't you almost done? Let's see if we can make it. How much time do I have? 8 minutes, okay. Strict scrutiny again applies as far as the burden of proof to each of these constitutional defenses. 24 is compelled expressive speech. Let's go to slide 24. That's it. Let's go to slide 15. Another quote from Masterpiece, just reading the bold. Nor can anyone reasonably doubt a wedding cake without words conveys a message. Words or not, this is Justice Gorsuch's concurring opinion. Words or not, and whatever the exact design, it celebrates a wedding. And if a wedding cake is made for a same-sex couple, it celebrates a same-sex wedding. Like an emblem or flag, a cake for a same-sex wedding is a symbol that serves a shortcut from mind to mind, signifying approval of a specific system, idea, or institution. It is precisely that approval that Mr. Phillips intended to withhold in keeping with his religious faith. Justice Thomas wrote a very similar concurring opinion. Everybody knows what a wedding cake is. Let's not be ridiculous. Number 25, viewpoint discrimination, looking at the last section of number 5 there, on this burden of proof, is prohibited. And that's exactly what we have. The viewpoint that's being suppressed is a perceived objection to same-sex marriage, or at least support only of biblical marriage between one man and one woman. Slide 26. Again, on the burden of proof, in every case, the government needs a compelling government interest for strict scrutiny and the least restrictive means, either of which apply here. And finally, slide 27. This is a slide that aggregates some of the wedding vendor cases across the nation. Jeff drafted his language, it's not from a case, but it is basically what these cases stand for. That religious wedding professionals are now protected by rulings in Arizona, Arkansas, Iowa, Kentucky, Minnesota, Missouri, Nebraska, North Dakota, and South Dakota. These rulings in states show that it is possible for harmony. People of faith and the LGBT community can live together through mutual toleration and respect. Indeed, Rosemary Perez says, why can't we respect each other? I was trying to respect them, but they basically turned to be very antagonistic and hostile when they learned our beliefs. And these cases have been applied to wedding videographers, wedding calligraphers, wedding photographers, and it will sure to be people that create, I think, the wedding websites, such as in the 303 creative case. But Masterpiece heralds that it should apply to First Amendment protection for wedding cakes. They just didn't need to reach it because the hostility of the Colorado Civil Rights Commission, they felt, was enough, even if there had been discrimination, to end that case. And I was, again, there in court, and Justice Kennedy, who got angry and red-faced when he said to the Colorado Civil Rights Commission attorneys, you were not respectful of Mr. Phillips' religious beliefs when you compared his views to racism. And that's where that decision came down. But this court is going to have to address this issue, and I appreciate the time and attention this court has given us to set forth our point of view. Thank you very much.
Thanks, Mr. LiMandri. We'll take a 5-minute recess, Mr. Mann, 5 minutes.